Judgments on Appeals from India by Pandit Prannath Saraswati, MABL, Pleader, High Court, Calcutta, and Judicial Commissioners Court, Oudh, and Bidhu Bhushan Banerjee, BABL, Volume 1, 1825 to 1862, Bhawanipur, published by Srinath Banerjee, 1880. Printed by B.M. Sen, Tomohur Press, Serampur. Preface. There can be no doubt that the there can be no doubt that the republication of a complete set of Privy Council judgments in Indian cases would be exceedingly useful to the legal profession and the general public. Such a set cannot now be conveniently had. The earlier volumes of the existing reports are not easily procurable, and even when they are procurable, they are sold at such extravagantly high prices that few can afford to purchase them. We have therefore deemed it advisable to collect and reprint in a convenient form the judgments of the Privy Council in Indian cases from the beginning of 1825 to the end of 1878. The work will be complete in two volumes, the first volume containing cases up to 1862 and the second up to 1878. All the cases given in the first three volumes of Knapp's reports and the first 9 volumes of Moore's Indian Appeals will be found in the present volume, which also contains several important cases not reported in either of them. No pains have been spared to make the present volume useful and acceptable to the public, and to enhance its usefulness, the headnotes appended to the cases have been rendered as clear and complete as possible. A copious index on the plan of a complete digest and a table of cases have also been added. The second volume will appear shortly. Prannath Pandit, Bidhu Bhushan Banerjee, Calcutta, February 1880. List of the Judicial Committee of His and Her Majesty's Most Honourable Privy Council appointed by virtue of the third and fourth will, number 4, C 41, for hearing and reporting on appeals to His and Her Majesty in Council, 1833 to 62. Lord Brougham, Lord High Chancellor of Great Britain, the Marquis of Lansdowne, Lord President, the Marquis of Salisbury, late Lord President, the Duke of Portland, formerly Lord President, the Marquis of Camden, formerly Lord President, the Earl of Chatham, formerly Lord President, the Earl of Bathurst, formerly Lord President, the Earl of Harrowby, formerly Lord President, the Earl of Eldon, formerly Lord Chancellor of Great Britain, Lord Viscount Sidmouth, formerly Lord President, Lord Stowell, formerly Judge of the High Court of Admiralty, Lord Lyndhurst, late Lord High Chancellor, Lord Winford, formerly Lord Chief Justice of the Common Pleas, Lord Denman, Lord Chief Justice of the late Queen's Bench, Lord Cottenham, Lord High Chancellor of Great Britain, Lord Abinger, Lord Chief Baron of the Court of Exchequer, Lord Gifford, Master of the Rolls, Lord Longdale, Master of the Rolls, Sir John Nicol, Judge of the Prerogative Court of the Archbishop of Canterbury and the High Court of Admiralty, Sir John Leach, Master of the Rolls, Sir William Alexander, formerly Lord Chief Baron of the Exchequer, Sir Lancelot Shadwell, Vice Chancellor of England, Sir Nicholas Conyngham Tyndall, Chief Justice of the Court of Common Pleas, the Honorable Thomas Erskine, Chief Judge of the Court of Bankruptcy, Sir William Garrow, Knight, formerly one of the Barons of the Court of Exchequer, Sir James Park, Knight, one of the Judges of the Court of King's Bench, Sir John Bernard Bosanquet, Knight, one of the Judges of the Court of Common Pleas, Sir Robert Graham, Baronet, formerly one of the barons of the Court of Exchequer. Sir John Bailey, Baronet, late one of the barons of the Court of Exchequer. Sir John Vaughan, Knight, one of the judges of the Court of Common Pleas. Sir Herbert Jenner, Knight, Judge of the Prerogative Court. List of the Judicial Committee. The Right Honorable Dr. Lushington, Judge of the Admiralty. The Duke of Buccleuch, late Lord President. Lord Vancliffe, late President. Lord Campbell, Chancellor of the Duchy of Lancaster. Sir Joseph Littledale, formerly one of the judges of the Court of Queen's Bench. The Right Honorable Sir James Levy, Knight Bruce, Vice Chancellor. The Right Honorable T. Pemberton Lee, Chancellor of the Duchy of Cornwall. The Right Honorable Sir Frederick Pollock, Lord Chief Baron of the Exchequer. Sir Thomas Wilde, Lord Chief Justice of the Common Pleas. The Right Honorable Sir James Wigram, Knight, Vice Chancellor. The Earl Granville, Lord President. Lord Cranworth, Lord High Chancellor of Great Britain. Lord Truro, late Lord High Chancellor of Great Britain. The Right Honorable Sir Edward Ryan, Knight, formerly Chief Justice of the Supreme Court at Calcutta. The Right Honorable Sir John Jervis, Knight, Lord Chief Justice of the Court of Common Pleas. The Right Honorable Sir John Romilly, Knight, Master of the Rolls. The Right Honorable Sir George James Turner, Knight, one of the Lord Justices of the Court of Appeals in Chancery. The Right Honorable Sir John Patterson, Knight, late one of the Judges of the Court of Queen's Bench. The Right Honorable Sir John Dodson, DCL, Knight, Judge of the Prerogative Court. The Earl Lonsdale, formerly Lord President. Lord St. Leonards, formerly Lord High Chancellor of Great Britain. Lord Chelmsford, late Lord High Chancellor of Great Britain. Lord Wensleydale, formerly one of the barons of the Court of Exchequer. Lord Kingsdown, Chancellor of the Duchy of Cornwall. The Right Honorable Sir William H. Mall, Knight, formerly one of the judges of the Court of Common Pleas. The Right Honorable Sir Alex J. Cockburn, Baronet, Lord Chief Justice of the Court of Queen's Bench. The Right Honorable Sir Creswell, Knight, Judge of Her Majesty's Court of Probate and Divorce. The Right Honorable Sir John Taylor Coleridge, Knight, late one of the judges of the Court of Queen's Bench. The Right Honorable Sir William Earl, Knight, Lord Chief Justice of the Court of Common Pleas. Lord Westbury, Lord High Chancellor of Great Britain. Privy Councillors and Assessors. Sir Edward Hyde East, Baronet, formerly Chief Justice of the Supreme Court at Calcutta. Sir Alexander Johnston, Knight, formerly Chief Justice of the Supreme Court of the Island of Ceylon. Sir Edward Ryan, formerly Chief Justice of the Supreme Court at Calcutta. The Right Honorable Sir Lawrence Peel, Knight, formerly Chief Justice of the Supreme Court at Calcutta. The Right Honorable Sir James William Colville, Knight, formerly Chief Justice of the Supreme Court at Calcutta. Footnote to Lord Kingsdown, Chancellor of the Duchy of Cornwall. On the 9th August 1858, the Right Honorable Thomas Pemberton Lee, Chancellor and Keeper of the Great Seal to His Royal Highness, the Prince of Wales, was created a peer by the title of Lord Kingsdown of Kingsdown in the county of Kent. A table of the cases reported in this volume. I think this should be skipped. Table of cases, table of cases, table of cases, table of cases. Privy Council judgments on appeals from India. May 1829, by petition from Bombay, in re the Justices of the Supreme Court of Judicature. The Supreme Court of Bombay has no power to issue a writ of habeas corpus except when directed to a person resident within those local limits wherein it has a general jurisdiction, or to a person out of those limits who is personally subject to its jurisdiction. The Supreme Court has no power to issue a writ of habeas corpus to the jailer or officer of the native court as such officer, it having no power to discharge persons imprisoned under the authority of a native court. The Supreme Court is bound to notice the jurisdiction of a native court without having it set forth specially in the written to a writ of habeas corpus. This case arose on the petition of Sir John Peter Grant, Knight, only surviving Justice of the Supreme Court of Judicature at Bombay. It stated that by letters patent of the 8th of December in the 4th year of the present reign, His Majesty was pleased to grant, direct, ordain, and appoint that there should be within the settlement of Bombay a court of record which should be called the Supreme Court of Judicature at Bombay, and did thereby create, direct, and constitute the said Supreme Court of Judicature at Bombay to be a court of record, and that the same should be that the same should consist of and be holden by and before one principal judge who should be and be called the Chief Justice of the Supreme Court of Judicature at Bombay, and two other judges who should be and be called the puisne judges of the Supreme Court of Judicature at Bombay, and that the said Chief Justice and the said puisne judges should severally and respectively be, and they were all and every of them thereby appointed to be justices and conservators of the peace and coroners within and throughout the settlement of Bombay and the town and island of Bombay and the limits thereof and the factories subordinate thereto and all the territories which then were or thereafter might be subject to or dependent upon the government of Bombay aforesaid, and to have such jurisdiction and authority as His Majesty's Justices of His Majesty's Court of King's Bench had and might lawfully exercise within that part of Great Britain called England as far as circumstances would admit. And that the said Supreme Court of Judicature at Bombay should have and use as occasion might require a seal bearing a device or impression of His Majesty's Royal Arms, and that all writs, summonses, precepts, rules, orders, and other mandatory process to be used, issued, or awarded by the said Supreme Court of Judicature at Bombay should run and be in the name and style of His Majesty and be sealed with the seal of the said Supreme Court, and that the King by the said letters patent constituted and appointed Sir Edward West, Knight, then Recorder of Bombay, to be the first Chief Justice, and Sir Ralph Rice, Knight, then Recorder of Prince of Wales Island, and Sir Charles Harcourt Chambers, Knight, to be the first puisne justices of the said Supreme Court of Judicature at Bombay. And the King did further direct, ordain, and appoint a certain jurisdiction to appertain to the said Supreme Court of Judicature for the hearing and determining of suits and actions arising in the territory subject to or depending upon the said government, subject to certain provisos, exemptions, and declarations in the said letters patent mentioned, and did appoint a certain form of proceeding for the commencing, prosecuting, hearing, and determining such civil suits and actions, and for the awarding and issuing of execution on the judgments pronounced therein. And that the King was also pleased to grant, ordain, and appoint that the said Supreme Court should be a court of equity and have equitable jurisdiction over the persons in the said latest patent described, and should be a court of oyer and terminer and jail delivery in and for the town and island of Bombay and the limits thereof and the factories subordinate thereto, and also a court of ecclesiastical jurisdiction within and throughout the town and island of Bombay and the limits thereof, and further that the said Supreme Court should be a court of admiralty in and for the said town and island of Bombay and the limits thereof and the factories subordinate thereto and all the territories which then were or thereafter might be subject to or dependent upon the said government. And that the said Sir R. Rice, Knight, resigned the office of Senior Puisne Justice of the said Supreme Court of Judicature at Bombay in November 1827. When the said Sir C. H. Chambers became Senior Puisne Justice thereof, And the said Sir R. Rice having resigned his office, the petitioner was by letters patent of the 30th of August 1827 appointed one of the puisne justices of the said Supreme Court in his room, and that he took his seat as such at Bombay on the 9th day of February 1828. And that the said Chief Justice Sir Edward West departed this life on the 18th of August 1828, and that on the third day of October in that year a letter was addressed, quote, to Sir C.H. Chambers and the petitioner as puisne justices of the Supreme Court of Judicature, dated Bombay Castle, 3rd October 1828, and signed by John Malcolm, the Governor, T. Bradford, Lieutenant General, Commander of the Forces, J. J. Sparrow, and John Romer, the second and third members of the Council. End of quote. Which letter was of the following tenor, quote, Honorable Sirs, we are quite aware that we transgress upon ordinary forms in addressing this letter to you, but the circumstances under which we are placed will, we trust, justify this departure from usage, and our knowledge of your private and public characters lead us to hope that what we state will be received in that spirit in which it is written, and that notwithstanding your strict obligations to fulfill every part of your high and sacred duty as British judges, you will, on this extraordinary occasion, deem yourselves at liberty to consider as much the objects as the rules of the court over which you preside, and viewing the intention of the legislature in its institution as directed to the aid and support of the government entrusted with the administration of this presidency, you will, for a short period, be induced by our representations to abstain from any acts, howsoever legal you may deem them, which, under the measures we have left ourselves compelled to take, and which we deem essential to the interests committed to our charge, must have the effect of producing open collision between our authority and yours, and by doing so not only diminish that respect in the native population of this country which it is so essential to both to maintain, but seriously to weaken by a supposed division in our internal rule those impressions on the minds of our native subjects, the existence of which is indispensable to the peace, prosperity, and permanence of the Indian Empire. This conclusion refers to a variety of circumstances which we are equally forbid from explaining as you are from attending to such explanation. But we deem it necessary to state our conviction of the truth of what we have asserted, expecting that it may have some weight with you as connected with the preservation of that strength in the government, which in all our territories, and particularly those we have so recently acquired, is the chief, if not the only power we possess for maintaining that general peace, on the continuance of which the means of good rule and of administering law under any form must always depend. Para 2. In consequence of recent proceedings in the Supreme Court, in the cases of Moro Raghunath and Bapu Gunnes, I think it's Bapu Ganesh, we have felt compelled, for reasons which we have fully stated to our superiors, to direct that no further legal proceedings be admitted in the case of Moro Raghunath, and that no returns be made to any writs of habeas corpus of a similar nature to those recently issued and directed to any officers of the provincial courts or to any of our native subjects not residing in the island of Bombay. Para 3. We are quite sensible of the deep responsibility we incur by these measures, but must look for our justification in the necessity of our situation. The grounds upon which we act have exclusive reference to considerations of civil government and of state policy, but as our resolution cannot be altered until we receive the commands of those high authorities to which we are subject, we inform you of them. And we do most anxiously hope that the considerations we have before stated may lead you to limit yourselves to those protests and appeals against our conduct in the cases specified, that you may deem it your duty to make, as any other conduct must, for reasons already stated, prove deeply injurious to the public interests, and can, under the resolution taken and avowed by government, produce no result favorable either to the immediate or future establishment of the extended jurisdiction you have claimed. A very short period will elapse before an answer is received to the full and urgent reference we have made upon this subject, and we must again express our hope that even the obligations under which we are sensible you act are not so imperative as to impel you to proceedings which the government has thus explicitly stated its resolution to oppose. We have the honor to be, etc., etc. End of quote. The petition then stated that on Monday, the 6th October instant, the Supreme Court being assembled for the dispatch of its judicial business, Sir C.H. Chambers caused this letter to be read to the court by the Clerk of the Crown, after which the petitioner, concurring with Sir C.H. Chambers in opinion regarding both the form and the substance of the communication, the court directed that the Clerk of the Crown should inform the Chief Secretary to the Government of the Presidency by letter that the said letter had been received and that the judges could take no notice thereof. That it was the intention of the said Sir C.H. Chambers and the petitioner to have laid before His Majesty in an humble petition the circumstances which were therein above set forth, and most dutifully and submissively to have besought His Majesty's royal protection against what they agreed in considering a most unconstitutional and criminal attempt on the part of those armed with the whole power, civil and military, of the Presidency to approach the Supreme Court of Judicature within the same, not by their humble petition or by motion, by themselves or their counsel in open court, the only ways in which the law for the wisest purposes permitted His Majesty's judges to be addressed, but by means of such covert and private communication as was strictly forbidden by the forms reared by the wisdom of ages, for the entrenching their persons against the danger and even the pollution of undue solicitation or menace, and this for the declared purpose of inducing the judges, notwithstanding their most sacred obligations to God, to the King, and to themselves, to refuse to administer justice according to what they should deem to be law, in compliance with such notions as those who had thus approached them might from time to time entertain of what they should call state policy. That while a petition to the above effect was preparing to be transmitted to England, Sir Charles Harcourt Chambers, then acting as Chief Justice of the said Supreme Court, suddenly died on the 13th of October 1828. The petition then proceeded at considerable length to explain the motives that influenced the petitioner and his colleague during these proceedings to impugn the conduct of the Governor and Council, and to show the benefit of the Supreme Court having the power to issue the writ of habeas corpus in the manner they claimed. It ultimately prayed that it might therefore please His Majesty to take the premises into his royal and most gracious consideration, and to give such commands concerning the same as to His Majesty's royal wisdom should seem meet for the due vindication and protection of the dignity and lawful authority of His Majesty's Supreme Court of Judicature at Bombay. The case of Moro Raghunath, which is alluded to in the petition, may be thus briefly stated. On the 25th of August 1828, a writ of habeas corpus ad subjudiendum directed to Pandurang Ramchandar for the production of the body of Moro Raghunath, his ward, was moved for before Mr. Justice Grant, the petitioner, at his chambers on the affidavit of Dinkar Gopal Dev, which stated that Moro Raghunath had been confined for nearly a year and was still kept in confinement by Pandurang Ramchandar against his wishes, against his will, and under circumstances attended with great hardship and cruelty. This motion was opposed by the Advocate General on the ground that Pandurang Ramchandar and Moro Raghunath were natives residing at Pune and not amenable to the jurisdiction of the Supreme Court. The granting of the writ was postponed for various reasons until the 30th of August, during which time additional affidavits were put in, and in these it was stated that Moro Raghunath, having made his escape from Pandurang Ramachandar on the 12th of July, was retaken and sent back again to his custody by persons acting under the order and by the directions of John Andrew Dunlop, Squire, a British-born subject and a provincial magistrate at Pune. After considerable discussion, the writ was ordered to issue and was made returnable to the court on the 15th of September then next. It was translated by order of the court into the Maratha language and duly served on Pandurang Ramchandar. A return was made and filed to this writ in these terms. Quote, I, Pandurang Ramchandar Dumdari, am the relation and friend of the Peshwa. I never in my life have been the servant of the English government or of the English. At the time the company's government took this country, they gave me word I should live without fear or molestation. Depending upon that, I remained in Pune. And as for my grandson, Moro Raghunath, I am his grandfather. He was placed under my care that I might take care of him according to the usual custom. He, the said boy, is 14 years old. For that reason, according to the Shastra of the Hindus, he is without knowledge. He is bound to behave agreeably to the orders of the person under whose charge he lives. And further, it is necessary to take care of the property and wealth of the boy. More than this, there is nothing, and there is nothing more done by me to him than by those to whose care a boy is delivered, or the usual orders of seniority in a Hindu's family. Should I by any chance do more or less the same? The same being made known to the Adalat at Pune, it would be immediately stopped. After Moro Raghunath's grandmother died, he was delivered into my charge according to the rule, and I agreed to undertake the charge in order that my grandson's wealth might not be ruined. Without the leave of those by whose authority I took the charge upon my head, I cannot relinquish it. Dated 10th of September 1828, 1st of Bhadrapad, Sud Shalabar 1750, the name of the year being Sarodhari. This return, end of quote. This return was objected to on two grounds. Firstly, that there was no return paratum habeo corpus. Secondly, that no reason was stated to excuse the disobedience, but that the writ ought not to have issued, which was a reason the court ought not to receive. And an attachment against Pandurang Ramchandar was moved for. The judges took time to deliberate on the question, and on the 29th of September, they delivered their judgment that a writ of alias habeas corpus should issue, returnable on the 10th of October then next. The case of Bapu Ganesh came before the Supreme Court on an application for a writ of habeas corpus ad subjudiendum to the head jailer of the jail at Thana, directing him to produce the body of Bapu Ganesh, then a prisoner in his custody. The writ was granted on the affidavit of one Babul Ranji, stating that he had applied to the jailer for a copy of the warrant under which Bapu Ganesh was confined and that it had been refused to him. The writ issued on the 10th and was made returnable on the 19th of September 1828. A return to it was made by the Nazir of the Court of Adalat of the Northern Konkan and the jailer to whom the writ was directed in these terms: that before the coming in of the writ, Bapu Ganesh was taken and detained in our custody by virtue of a certain order in writing of the Adalat Court of the Zilla of the Northern Konkan in the Maratha language and in the following form, end of quote, which was set out and stated in effect that Bapu Ganesh, having been found guilty of embezzlement, was sentenced to 2 years imprisonment and a fine of 350 rupees, or in default of payment of that sum to a year's additional imprisonment. The body of the prisoner not having been produced on the 19th, the judges would not suffer the written to be read and directed an attachment to issue against the jailer. On the 26th, the attachment was set aside on payment of the costs at the instance of the Advocate General, and Bapu Ganesh having been brought into court, the written was read and held insufficient because the authority of the Adalat court was not stated in it. 4 days' time was allowed to amend it, the prisoner being in the meanwhile committed to the jail at Bombay. The written was not amended within that time, the Advocate General stating to the court that the reason why it had not been amended was because government would not suffer the authority of the provincial courts to be questioned. And Bapu Ganesh was discharged from custody. No judgment was delivered in this case, but the report of the Privy Council, which was affirmed by His Majesty, was, quote, that the writs of habeas corpus were improperly issued in the two cases referred to in the said petition. that the Supreme Court has no power or authority to issue a writ of habeas corpus except when directed either to a person resident within those local limits wherein such court has a general jurisdiction, or to a person out of such local limits who is personally subject to the civil and criminal jurisdiction of the Supreme Court. That the Supreme Court has no power or authority to issue a writ of habeas corpus to the jailer or officer of a native court, as such officer, the Supreme Court having no power to discharge persons imprisoned under the authority of a native court. That the Supreme Court is bound to notice the jurisdiction of the native court without having the same specially set forth in the written to a writ of habeas corpus. End of note. Note. Before this decision had been pronounced, the Supreme Court at Bombay had closed under the following circumstances. No return having been made on the 10th of October 1828 to the writ of alias habeas corpus directed to Pandurang Ramchandar, a pluris habeas corpus was ordered to issue, returnable immediately and marked in the penalty of 10,000 rupees. To this writ also no return was made, and on the 23rd of February 1829, Mr. Justice Grant ordered an attachment to issue against Pandurang, and that it should be directed to the Governor and Council in order that they might execute it by such person or persons as they might depute for that purpose. He also directed a letter to be sent at the same time to the Secretary of Government to explain the reasons of the court acting in this manner and enclosing copies of the affidavits and proceedings in the case. Upon the receipt of this letter and writ, the Secretary replied that it was the intention of the government to persist in the line of conduct expressed in the letter of the 3rd of October 1828 until they received orders from their superiors in England. After this reply, Mr. Justice Grant, on the 1st of April 1829, declared that the court had ceased on all its sides and that he would perform none of the functions of a judge until the court had received an assurance that its authority would be respected and its process obeyed and rendered effectual by the government of the Presidency. From Asiatic Register, Volume 28, page 351, et sequitur. 23rd June 1829. On appeal from Calcutta. Ram Tanu Malik, Ram Konai Malik and others, appellants, and Ram Gopal Malik and Ram Ratan Malik, respondents. Construction of a Hindu will. Where a testator directed a religious work to be performed at one place and a temple to be built at another, it did not follow that the work at the first place means the erection of a temple. Referred to the master to inquire whether there was any religious building amongst the Hindus less expensive than a temple. Where a testator directed a ghat to be built, referred back to the master to inquire whether by the usages of the Hindus it was necessary that it should also be consecrated. Where a testator made two of his sons his executors and directed that when they should perform a religious or other act, they should give notice to their brothers, and they should all perform the act. Otherwise, whatever the executors might think proper, they should do, and should anyone raise objections to it, they should be inadmissible. Held that it did not give the executors an unlimited discretion in expending the testator's fortune in religious ceremonies. This was an appeal from an order of the Supreme Court of Judicature at Fort William in Bengal of the 2nd of May 1821, disallowing exceptions taken to a report of the Master of the 9th of June 1820 in a suit instituted by the appellants against the respondents for an account of the property of which Nemi Charan Malik, the father of all the parties to these suits, died possessed. The report of the master was made in pursuance of an order to him to inquire and report, among other things, what sum would be requisite for the performance and execution in a suitable manner of the several acts, works, and ceremonies directed by the will and testamentary papers of Nemi Charan Malik to be performed and executed. Nemi Charan's will and testamentary papers consisted of 4 written orders or directions, all of the same date and addressed by him to the respondents, who were his eldest and 4th sons and whom he constituted his executors. The part of them to which this order referred were the following: quote, "You will, from my estate, perform my obsequies and those of my wife, and constantly perform religious acts in a suitable manner. Whenever you perform any religious or other acts, you two brothers will inform the other six brothers. And if they acquiesce in your opinions, you eight brothers will perform the act collectively. Otherwise, whatever you two brothers think proper, you will do. And should anyone raise objections, it is inadmissible." Quote, ellipsis, "It is my desire to perform some work at Sri Sri Brindavan and Sri Sri Jagannath, and to make a ghat on the bank of the Ganges, and to cause the Srimad Bhagavad, the Sri Mahabharat, the Valmiki Puran, and the Chaitanya Mangal to be chanted. Should good or harm happen to me before the completion of these, you will perform all these acts and defray the expense thereof from the residue of my estate which remains in your charge. It is my wish you to make a temple for the Sri Sri Mahaprabhuji at Ambika. Should I die before the completion of this, you will make the temple and consecrate it from the residue of my estate which remains under your charge." End of quote. The proceedings in this appeal were ex parte, no one appearing for the respondents. Spanky, Sergeant, and Jammet, who appeared for the appellants, were desired, however, by the court to state and argue the case, which they accordingly did. Lord Winford: "The interest of sovereigns, as well as their duty, will ever incline them to secure, as far as it is in their power, the happiness of those who live under their government. And no person can be happy whose religious feelings are not respected. If this were a case between Europeans and Hindus, we would not take a step without the assistance of some of the persons from India who are acquainted with the usages of this country with regard to the ceremonies that ought to be observed and the works that ought to be performed on the death of an opponent relative. For we should fear lest by the judgment which we might advise His Majesty to pronounce, the feelings of the people of Hindustan might be wounded. But this is a case where some members of a Hindu family object to the allowance that has been made to other members of the same family for the expenses of the obsequies of the father of all the litigant parties, and of the works which that father by his will directed to be done by those to whom he bequeathed his fortune. With respect to the obsequies, as the will gives no directions how they are to be performed, we have only to consider upon the evidence which these parties have laid before us, whether the sums allowed for their performances are more than have usually been expended at the funerals of persons of the same rank and fortune as the deceased. If they are more, as some members of the family object to them, we ought not to sanction the expenditure. The sums which have been allowed for the obsequies and works exceed a sixth of the property of the deceased, although he left behind him 8 sons and 2 daughters. This will not surprise persons who are acquainted with the history of countries where the Roman Catholic religion has been established. In those countries, a much larger proportion of men's substance was frequently directed to what we should now call superstitious uses. By the laws, for instance, now existing in Spain, a person, whatever his family may be, may give to the church 1/5 of his fortune. I cannot, however, find upon the evidence any case in which in India more than 3% has been expended in obsequies and works, and the persons on account of whom in those cases such allowances have been made were men of superior caste and larger fortune than the deceased. The sums too which have been here allowed exceed what had been expended by the deceased and his brother for the funeral of their mother. Indeed, although much evidence has been given as to what was usually expended on these occasions, and although that was the proper inquiry for the master to make, he has satisfied himself with endeavoring to ascertain what had been actually expended and not what ought to have been expended. Such a mode of settling a claim of this sort would leave families entirely at the mercy of those who execute the will of their parents, as they might expend whatever sum they liked, however ruinous such expenditure might be to those who had the property bequeathed to them. It is true that in the will, all the children are to be required by the executors to attend the ceremonies, and if they decline attending them, the executors are to perform those ceremonies by themselves, and no one is to be permitted to object to the manner in which they shall have been performed. But we do not think this clause gives to the executors a power of incurring any expense they might think proper without control and without account. The meaning of these words is this: if you do not think proper to attend the obsequies of your father, you shall not be heard afterwards to find fault with the manner in which the ceremonies were performed, or to raise trifling objections to the expense incurred. But these words do not give the executors an unlimited authority to waste the property of the deceased and to leave his children destitute. With respect to the works to be done, the master has reported that a temple should be built and consecrated at Sri Sri Brindaban and a ghat built and consecrated on the Ganges. Now, when the deceased intended that a temple should be built, he has said so in express words. So, when he intended that a building should be consecrated, he has expressed that intention in his will, but he has not directed that a temple was to be built at Sri Sri Brindaban or that the ghat was to be consecrated. And the master has not reported to us any evidence from which he could have ascertained these to have been his intention. We have therefore nothing to guide our judgment but the will of the deceased, and judging from that, we cannot say we think the master has decided rightly. If no direction had been given in the will to build a temple at any place, we might have thought with the master, who ought to be better acquainted with the usages of the Hindus than we can be, that a temple was the only building a dying Hindu could have contemplated when he directed a work to be performed at Brindaban, as we must suppose he meant a building to be used for religious purposes. But as there are other buildings used for religious purposes, until this matter is more fully explained to us, we are bound to suppose, since he has not directed a temple to be built at Brindaban, although he has directed one to be built at another place, that he meant some other building to be erected at Brindaban. Otherwise, his directions with respect to the one place would have been in the same terms as they are with respect to the other. If there is any usage among the Hindus that a ghat or landing place should always be consecrated, we should have had evidence of that usage. In the absence of such evidence, the testator having directed other buildings to be consecrated and not having given any directions for the consecration of this ghat, we think that the master was not authorized by the will to allow the expenses attending the consecration of it. For these reasons, we shall advise His Majesty to reverse the decree of the Court of Calcutta and direct that court to refer this case again to the master, ordering him to inquire what, according to the usages of the Hindus, should be expended in the obsequies of a person of the caste and fortune of Nemi Charan Malik, and whether there are any cheaper religious buildings than temples, and whether all gods must be consecrated, and that the master be directed to reduce the allowance on these accounts to what is usual and proper in such a case as the present. 25th May 1825, 3rd April 1827, 5th March 1830. On appeal from the Supreme Court at Calcutta, Lewis Owen Edwards, appellant, and Howard Ronald, George Dixon, and Thomas Learmouth, respondents. A certificate of conformity obtained under a commission of bankrupt in England is a bar to an action for a debt contracted by the bankrupt at Calcutta previously to his bankruptcy, although the creditor had no notice of the commission and was resident at Calcutta. The respondents brought an action of assumpsit in the Supreme Court for goods sold and delivered and work and labor done, and on the common money counts on the 4th of December 1821. The appellant pleaded first the general issue, secondly a general plea of bankruptcy by a creditor at Calcutta, and that the causes of action accrued before he became bankrupt, and thirdly a special plea of bankruptcy. Quote, that the said defendant here therefore, that the said defendant heretofore and before and until the suing out of the commission of bankruptcy hereinafter mentioned was a merchant and trader and did use and exercise the trade of a merchant by way of bargaining, exchanging, bartering, and chevisance, and sought his trade and living by buying and selling, to wit at London, to wit at Calcutta aforesaid. And the said defendant so using and etc. afterwards, to wit on the 18th day of May 1820, to wit at London and etc., became and was indebted as such merchant and dealer to divers and lawful creditors of him, the said defendant, in divers large sums of money to a large amount, to wit and etc. And the said defendant, being so indebted as aforesaid, and being a subject of Great Britain, and so using and etc. afterwards, to wit, on the same day and year last mentioned at London, to wit, etc., the said several debts to the said several creditors being then and there due, and wholly unpaid and unsatisfied, he, the said defendant, then and there became and was a bankrupt within the true intent and meaning of the several statutes then and still in force in that part of the United Kingdom of Great Britain and Ireland called England, concerning bankruptcy made and provided some or one of them. And thereupon, afterwards, to wit, on the 19th of May in the year aforesaid, at Westminster, to wit, and etc., a certain commission of bankruptcy under the Great Seal of the United Kingdom of Great Britain and Ireland, bearing date at Westminster, the same day and year last aforesaid, grounded upon the said several statutes, some or one of them, was on the petition of Edwards, a just and lawful creditor of the said defendant, and to the amount required by law, and concerning to the provisions of the said several statutes, or some of them, duly awarded and issued against him, the said Lewis Owen Edwards directed to certain commissioners, and etc., thereby giving full power and authority to the said commissioners, four or three of them, to execute the said commission as in and by the said commission, relation being thereunto had, and etc., by virtue of which said commission, and by force of the said several statutes concerning bankrupts, the major part of the said commissioners named in the said commission afterwards, to wit, on the 19th of May 1820 aforesaid at London, to wit, etc., did in due form of law find, adjudge, and declare the said defendant to be, and that the said defendant had become and was bankrupt within the true intent and meaning of the several statutes made and then in force concerning bankrupts. And further, that afterwards, to wit, on Saturday, the 19th of May 1820 aforesaid, at Westminster, to wit, and etc., due notice was given and published in the London Gazette that such commission of bankruptcy had been and was awarded and issued forth against him, the said defendant, and that he, the said defendant, had been declared bankrupt thereon and refused to surrender himself. And further, that three several meetings were duly appointed for his surrendering himself and making a full disclosure and discovery of his estate and effects, and finishing his examination under the said commission according to the form of the statute, etc., and that he duly surrendered himself to the major part of the said commissioners in and by the said commission named and authorized, and submitted himself to be from time to time examined touching the disclosure and discovery of his estate and effects. And at the last of these three meetings at London, to wit, etc., the said defendant finished his examination upon oath before the said commissioners, and upon such his examination, then and there made a full disclosure and discovery of his estate and effects. And further, that he hath always, from the time of issuing forth the said commission hitherto, to wit, at London, to wit, etc., in all things conformed himself to the provisions of the said several acts of parliament made and then in force as aforesaid concerning bankrupts, particularly of a certain act of parliament made in the 5th year of the reign of his late majesty King George II, entitled An Act to Prevent the Committing of Frauds by Bankrupts. And further, that he, the said defendant, afterwards, to wit, on the 17th of June 1820, to wit, at London, and etc., duly obtained his certificate of conformity under the said commission to the said statutes made, and then in force as aforesaid concerning bankrupts, and which said certificate was afterwards and before the commencement of this suit to wit, on the 13th of July 1820 aforesaid, to wit, at Westminster, to wit, at Calcutta aforesaid, duly allowed and confirmed by the Right Honourable John Lord Eldon, Baron Eldon of Eldon in the county of Durham, then and there being Lord High Chancellor of Great Britain, according to the form of the statute in that case made and provided. And further, that the said several causes of action in the said plaint mentioned accrued, and each and every of them did accrue to the said plaintiffs before the said defendant so became a bankrupt as aforesaid, to wit, at London, etc. End of quote. The respondents joined issue upon the first plea, and to the second replied, quote, that the said defendant, after he became bankrupt and before the filing of said plaint, ratified and confirmed the said several promises and undertakings in the said plaint mentioned. End of quote. Upon which replication, the appellant afterwards took issue, and to the last plea, the respondents replied as follows, viz. Quote, that the said several promises and undertakings in the said plaint mentioned, and each and every of them were and was made, and that the said several causes of action in the said plaint mentioned, and each and every of them arose and accrued to the said plaintiffs at Calcutta, at Fort William, in Bengal, in the East Indies, and not elsewhere, and that neither at or from the time of his the said defendant's becoming a bankrupt, as in the third plea mentioned, until or at the time of his obtaining his certificate under the commission in the said third plea mentioned, and of the same being confirmed and allowed by the Lord High Chancellor of Great Britain, as the said third plea also mentioned, they the said plaintiffs had any notice of the said bankruptcy of the said defendant, or of the issuing forth of the said commission, or of the proceedings, or of any of them had under the same as in the third plea mentioned, and that they the said plaintiffs during all the times aforesaid were resident in the province of Bengal, in the East Indies aforesaid, and etc. End of quote. To this replication, the defendant demurred generally, and the plaintiffs joined in demurrer. The issue, in fact, came on to be tried on the 1st of February 1822, Sir Francis McNaughton being the only judge present, when a verdict was found for the respondents on the general issue, damages 6,992, Sikka rupees 7 annas 3 pice and costs, and a verdict was found for the appellant on the second issue. On the 2nd of February 1822, the demurrer was called on for argument, but the counsel for the appellant declining to argue it in consequence of a former decision of the Supreme Court upon the same point, it was therefore overruled and judgment given for the respondents. From this decision, the present appeal was instituted. It came on to be heard on the 25th of May 1825, but was then ordered to stand over until an appeal from the Court of Session in Scotland in the case of the Bank of Scotland versus Cuthbert, which was then supposed to have been instituted to the House of Lords and was in pari materia should have been determined. After some time, however, it was ascertained that no appeal had ever been instituted against the decision in that case, and the cause therefore was argued before their lordships on the 3rd of April 1827. The reporter has been unable to procure any note of this argument. The reasons annexed to the printed case for the appellant, which were signed by Horn, Casey, and Rose Casey, were, quote, because the certificate in the pleadings mentioned and relied upon was duly obtained by the appellant by virtue of the several statutes concerning bankruptcy in England, and is by the law of England a legal bar to all debts contracted prior to the appellant becoming bankrupt, and among others to the debts contracted in Calcutta aforesaid, a place governed by and subject to the laws of England, and the said certificates admitted by the pleadings ought to have been allowed as such legal bar to the said action in the said Supreme Court, which being a court constituted by charter from the Crown, pursuant to an act of Parliament in that behalf, and administering justice according to the laws of England, ought to have given effect to the certificate granted by virtue of the said several statutes. That the said issue of fact joined on the replication to the said first plea of bankruptcy being found for the appellant, the said plea is a bar to the said action, and the appellant was entitled to judgment on the whole record. That the appellant was entitled to judgment on the said demurrer stated and alleged in the said replication to the said second plea of bankruptcy are not sufficient in law to avoid the legal effect of the matters pleaded in the second plea and by the said replication admitted to be true. End of quote. The reasons annexed to the printed case for the respondents, which were signed by the Solicitor General Tyndall, were, quote, because the law of England by which bankrupt is discharged by his certificate from debts contracted before his bankruptcy depends upon a statute which has no provisions applying to the case of a debt contracted and sued for in the East Indies. Because the justices of the Supreme Court of Judicature at Fort William in Bengal have no jurisdiction by the charter granted under the 13th Geo 3C 63 to give the effect to the bankrupt certificate which is contended for by the plea. End of quote. The case being one of great importance, their lordships took time to deliberate upon it, and the final judgment of the court was delivered by the Lord Chancellor in writing on the 4th of March 1830 in these terms. I have read and considered the papers in the above case and am of opinion that the judgment of the court in India ought to be reversed. I think the certificate was in this case a sufficient bar. End of quote. 3rd and 19th June, 14th July 1830. On appeal from the Supreme Court of Judicature at Bombay, the Honorable Mountstuart Elphinstone and Henry Dundas Robertson, appellants versus Hirachand Bedrichand and Jalmel Anup Chand, executors of Amir Chand Berdachand, respondents. The members of the provisional government of a recently conquered country seized the property of a native of the conquered country who had been refused the benefit of the articles of capitulation of a fortress of which he was governor, but who had been permitted to reside under military surveillance in his own house in the city in which the seizure was made and which was at a distance from the scene of actual hostilities, held that the seizure must be regarded in the light of a hostile seizure and that a municipal court had no jurisdiction on the subject. Sembel. The circumstances that at the time of the seizure and the city where it was made had been for some months previously in the undisturbed possession of the provisional government, and that courts of justice under the authority of that government were sitting in it for the administration of justice, do not alter the character of the transaction. This was an appeal from a judgment of the Supreme Court of Bombay dated the 6th of February 1827, awarding to the respondent 1,745,290 rupees, 3 quarters 32 riyas damages and 16,303 rupees, 3 quarters costs. The action in which it was given had been brought in trover appellants. It The action in which it was given had been brought in trover by Amir Chand Berdachand against the appellants and the East India Company for the recovery of damages for the seizure of treasure to a large amount from Naroba Autia, a nobleman of high rank under the Maratha government and formerly treasurer to the Peshwa, to whom Amir Chand was executor. The circumstances under which the seizure took place appeared on the trial to be as follows. On the 16th of November 1817, after the Battle of Kirki, the Peshwa Bajirao left his capital Pune, which was the next day taken possession of by the British forces. On the 15th of December 1817, the Marquis of Hastings, the Governor General of India, appointed the appellant Elphinstone sole commissioner for the settlement of the territory conquered from the Peshwa, with authority over all the civil and military officers employed in it, and also authorized him to nominate a secretary and such other officers as might be necessary to assist him in the functions of his office. Mr. Elphinstone, on the 11th of February 1818, issued a proclamation at Satara in which, after setting forth various acts of aggression by the Peshwa against the British government, he proceeded to state, quote, that by these acts of perfidy and violence, Bajirao has compelled the British government to drive him from his masnad and to conquer his dominions. For this purpose, a force has gone in pursuit of Bajirao, which will allow him no rest. Another is employed in taking his forts. A third has arrived by the way of Ahmednagar, and a greater force than either is now entering by way of Kandesh under the personal command of His Excellency Sir Thomas Hislop. A force under General Monroe is reducing the Carnatic, and a force from Bombay is taking the forts in the Konkan and occupying that country so that in a short time no trace of Bajirao will remain. The Raja of Satara, who is now a prisoner in Bajirao's hands, will be released and placed at the head of an independent sovereignty of such an extent as may maintain the Raja and his family in comfort and dignity. With this view, the fort of Satara has been taken, the Raja's flag has been set up in it, and his former ministry have been called into employment. Whatever country is assigned to the Raja will be administered by him, and he will be bound to establish a system of justice and order. The rest of the country will be held by the Honorable Company. The revenue will be collected for the government, but all property, real or personal, will be secured. All Vatan and Inam, hereditary property, Varshasam, annual stipends, and all religious and charitable establishments will be protected, and all religious sects will be tolerated, and their customs maintained as far as it is just and reasonable. The farming system is abolished. Officers shall be forthwith appointed to collect a regular and moderate revenue on the part of the British government, to administer justice, and to encourage the cultivators of the soil. They will be authorized to allow of remissions in consideration of the circumstances of the times. All persons are prohibited from paying revenue to Baji Rao or his adherents or assisting them in any shape. No reduction will be made from the revenue in consequence of such payments. Vatandars and other holders of lands are required to quit his standard and repair to their villages within 2 months from this time. The zamindars will report the names of those who remain, and all who fail to appear in that time shall forfeit their lands and be pursued without remission until they are entirely crushed. All persons, whether belonging to the army or otherwise, who may attempt to lay waste the country or to plunder the roads, will be put to death wherever they are found. End of quote. Mr. Elphinstone, by a letter dated the 6th of February 1818, appointed the other appellant, Captain Robertson, provisional collector and magistrate of the city of Pune and the adjacent country. He had been previously nominated by General Sir Lionel Smith to the command of the guards there, and he retained this command until September 1818, when he relinquished it to Major Frieran. Mr. Elphinstone's letter proceeded in these terms. Quote, the extent of your district will hereafter nearly correspond with that of the Prant of Pune. But until the neighboring districts shall have been settled, I beg you not to confine your exertions to those limits, but endeavor to bring under your authority as much of the country as may be within your power. The first consideration, therefore, is to deprive the enemy of his resources, and in this and all other points, everything must be made subservient to the conduct of the war. All arrangements that interfere with that object must be reserved for times of greater tranquility. End of quote. The letter then proceeded to give instructions as to taking possession of the enemy's country, for rewarding the potels and villages which might declare in our favor, and for sending native agents and parties of Sibbandis to places where their presence might be useful, and to authorize Captain Robertson to entertain 1,000 Sibbandis or more if he should find them necessary. Quote, some organization, it was observed, might be resorted to by which this species of soldiery might be improved. But it was to be remembered that it did not suit our policy to preserve a military spirit amongst them, but to allow them to sink into judges and collectors' peons. When a village has once submitted, any practices in favor of the enemy must be punished as acts of rebellion by martial law. The commander-in-chief at Pune will be directed to assemble a court-martial for the trial of such persons as you may think fit to bring before it, and to inflict capital punishment immediately on conviction. The same course must be adopted with regard to persons at Pune who shall conspire against our government, and likewise with all banditti who may assemble in the neighborhood of the capital. I particularly call your attention to the necessity of inflicting prompt and severe punishment on persons of this description. Prisoners taken from the body of Baji Rao's troops who may pass through your district in the course of military operation must for the present be regarded as regular troops. But parties sent to plunder the country are in all cases to be considered as freebooters and either refused quarter or put to death after a summary inquiry when there is any doubt of their guilt. All other crimes you will investigate according to the forms of justice usual in the country, modified as you may think expedient, and in all cases you will endeavor to enforce the existing laws and customs unless where they are clearly repugnant to the reason and natural equity. The same rules apply to civil trials, in which I particularly recommend the adoption of that system of arbitration already prevalent, subject to your confirmation. You will not fail to bear in mind the necessity of adhering to the customs of the country during the present provisional government. This may even be extended to the exemption of Brahmins from capital punishment, except when guilty of treason or of joining banditti in plundering the country. All established religious institutions are to be maintained and the expense to be allowed by government. This is of course not to extend to Bajirav's establishment for performing magical ceremonies, Anushtan, nor to his personal charities, but such of the former as are of ancient institution, like the annual Anushtan for rain at Pashani, and such of the latter as seem required by humanity, ought nevertheless to be kept up. You will exercise your own judgment on the subject. To enable you to protect the country from small parties of banditti and insurgents, a detail of 12 companies of sepoys and 200 auxiliary horse will be placed at your disposal as soon as the state of the garrison of Pune will admit of. In case you should require further aid, you will apply to the commanding officer, who will be requested to afford it to the utmost extent of his means. But it must rest with him to judge of the practicability of the service required and of the prudence of sparing the necessary detachment from his force. If any considerable portion of the enemy's army should approach Pune, all arrangement for the protection of the country must rest with the commanding officer, and you will no doubt think it advisable on such occasions to place your own parties at his disposal, retaining no more than are absolutely necessary for the purposes of police. In like manner, you will have the exclusive command of the guards in the town, but when threatened by an enemy, you will see the necessity of placing them under the commanding officer and allowing him to make all arrangements he may think necessary for the defense of the place. You will, of course, apprehend all sepoys or followers who may be found disturbing the peace of the city or marauding in the neighboring villages, but you will send them to the commanding officer per punishment, furnishing him with all information you may possess in proof of their guilt. End of quote. The letter then proceeded to give full instructions as to the arrangements that were to be pursued in the collection of the revenue, the assurances that were to be given to the landed proprietors of the protection of property, the line of conduct to be pursued to the Bhils and Ramusis, and to direct that the police of the country should be managed through the Patels, supported when necessary by the Sabbandis and regular troops. It also contained a direction to make over Baji Rav's property to the price agent, quote, but any part of it which the religious or other prejudices of the people required to be respected is to be retained on account of the public, the value being fixed in communication with the price agent. Gokla's and Trimbakji's property is also to be considered as prize. I have the honor to enclose a copy and translation of a proclamation I have issued to the inhabitants of the Peshwa's former dominions. I beg you to pay scrupulous attention to all the promises contained in it. I need not point out to you the great attention that must be paid to the peculiar prejudices of the inhabitants of Pune. Beef is on no account to be killed in the town or anywhere but in our own camps for the use of the European troops. No European soldiers are to be allowed to enter the city on any account, and the former prohibition against officers and gentlemen visiting it without permission unless on duty is to be strictly kept up. No European of any description is to be permitted to reside within the city. End of quote. Under this letter of instructions, Captain Robertson continued in possession of the government of Pune and the adjacent country until the time of the seizure of the treasure, an account of which the action was brought. After the defeat at Kirki, the Peshwa kept his army moving about in different parts of his territory until the latter end of the month of May 1818, when he was finally driven out of it, and on the 3rd of the following June, he surrendered himself and his army in Khandesh to Sir J. Malcolm. Naroba left Pune at the same time as the Peshwa. He did not, however, continue with that prince, but immediately went to the fortress of Raigar, of which he was governor, and he remained there in that character until the 9th of May 1818, when the fortress surrendered after a fortnight's siege to Colonel Prother. By the articles of capitulation, the inhabitants of the fortress were allowed to go to whatever place they might choose and take away their own property, but not any other property. Naroba was, however, suspected by Colonel Prother of having fraudulently sent away large quantities of treasure, the property of the Peshwa, and the colonel, under that impression, caused his baggage to be searched on going out of the fort. Four boxes filled with gold coin and jewels, together with 38 empty money bags, were found in it and were seized by the colonel as public property, which Naroba had no right to carry away. The colonel made a report to the government of his conduct and suspicions of Naroba, and in consequence of this report, orders were sent both to him and Captain Robertson to seize Naroba's person. Naroba went from Raigar to Pune and resided there until the time of the seizure in question in his own house, which had belonged to him previously to the commencement of hostilities. Considerable discussion took place, however, in the course of the argument before the Privy Council as to the manner in which he went there and the character in which he was considered by government during his residence. According to the statement of his executor, Amarchand, in a memorial which he presented to the governor of Bombay before this action was brought and which was read in evidence at the trial in the court below, Colonel Prother seized his person and after confining him for 3 or 4 days, sent him under a guard to Mr. Elphinstone at Pune, who released him and allowed him to go to his own house, over which, however, a guard was placed, and he remained thus in a state of confinement and arrest until the time in question. The correctness of this statement was, however, questioned by the counsel for the respondents on the authority of a passage in a letter from Colonel Prother to Mr. Elphinstone, dated at the camp near Palia, 17th of June 1818, which had been tendered in evidence at the trial on the part of the appellants and had been rejected by the court below. It had, however, been printed in the papers laid before the council. The passage in quote, as Mr. Secretary Warder has authorized me to secure the person of Outya, if found in the company's territories, I suppose he is not gone as he intended to Pune. If he has arrived and resides there, of course, it will be attended with no difficulty in securing his person, if such a measure may by you be thought necessary. End of quote. The seizure of the treasure for which this action was brought took place on the 17th of July 1818, when Captain Robertson, having been informed that a quantity of public treasure which had been carried out of Raigar by different persons of the garrison in fraud of the capitulation had been brought to Naroba at Pune and was secreted by him there, caused his house to be searched by his assistant in the Revenue and Judicial Department, Mr. Lumsden, and the commander of the Sibbandis, Captain Houston, accompanied by a party of troops acting under their orders. They found there 14 bags of Venetians or sequins and 14 bags of gold mohurs, which they seized together with Naroba's account books. Naroba was at the same time, together with his chief clerk, Dhondu Ballal, committed to prison. They were both of them during their imprisonment repeatedly interrogated by Captain Robertson respecting this treasure, and Naroba was at length liberated on the 7th of November 1818 upon delivering up 5 more bags of Venetians, which Captain Robertson was induced to believe he had secreted of the public money in addition to the bags which had been seized. He also entered into security for his personal appearance when required. During the time of these transactions, no actual hostilities were carried on in the immediate neighborhood of Pune. The headquarters of Major General Sir Lionel Smith, whose command extended over Pune and the country adjacent, were, from the time of the expulsion of the Peshwa from his dominions in May 1818 to December in that year, at Sarur, which is distant about 42 miles from Pune, according to his evidence, which was taken in the court below. Quote, during that period, he was constantly backwards and forwards between Pune and Serur and was in the habit of receiving reports as to the tranquil state of the country or otherwise as brigadier of division. Wherever he received information that the horsemen of the enemy had means of reassembling, he dispatched troops to preserve the tranquility of the country and see that they did not reassemble. He considered that he considered that he anticipated the tranquility of the country by sending the detachments, and if he had not sent the detachments, he considered they would have been up again. They were not subdued but dispersed. He knew of 30,000 of the military class dispersed about the country. He was in constant correspondence with the commissioner, both on military and political subjects, during 1818 and long afterwards. He corresponded with the commissioner on the disposal of our troops over the country. The commissioner consulted him in the first instance and he gave him his opinion of the military arrangements. He considered it to be necessary that the force should be very strong to keep the tranquility of the country. The peace garrison of Pune was only 2 battalions of native infantry, but in 1818 it consisted of 4 battalions of native infantry, an European regiment, and a regiment of cavalry. He should say 3,500 effective men. He considered it a necessary precaution to let everybody see we had an overwhelming force on account of there being a disaffected population and the fact of one government having been set up and the character of the people being turbulent, and that these causes for keeping up a great force at Pune continued during the whole of 1818 and for a later period. He kept his force at Serur in a state of complete readiness for the field without any reduction of men and did take the field in October in that year when he went down southwards towards the Krishna. End of quote. This evidence of the state of the country was corroborated by several other officers. During this period also, no disturbance appeared to have taken place in the city of Pune itself, and no attack was made upon it, although the guards there were stated to have been more upon the alert and stronger than in peaceable times. A court of Adalat was also opened there, and Captain Robertson presided as judge in it, both on civil and criminal trials. He performed his judicial duties in the same way as they had been performed under the Peshwa's government. Notwithstanding, however, the Peshwa's surrender of himself and his army to Sir J. Malcolm on the 3rd of June 1818, some of his fortresses still held out against the English, and hostilities were not terminated in the province of Khandesh until the surrender of Amalnair in the December following. Naroba, after his release, applied to the governor of Bombay for the restoration both of the treasure which had been taken from him by Colonel Poradar at Raigar and from his house at Pune by Captain Robertson's orders, and also of the 5 bags of Venetians which he had subsequently given up to Captain Robertson. The government referred his claim to Mr. Chaplin, who succeeded Mr. Elphinstone in the office of Commissioner of the Deccan. Mr. Chaplin, after examining Naroba himself and investigating his accounts, made a report to government in the year 1821, the nature of which did not appear on the trial. The government persisted, however, in refusing to restore the treasure. Naroba died in the following year, but the claim was renewed by his executor, Amarchand Berdachan, who in the later end of the year 1825 commenced the action of trover against the appellants and the East India Company, from the judgment in which this appeal was instituted. The particulars of his claim were sent by his attorney to the attorney of the defendants and were afterwards read at the trial. They consisted of 4 accounts. The first was of gold coin, jewels and shawls, the property of Naroba seized by Colonel Prodher at Raigar. The second of gold Venetians and mohurs, the property of Naroba seized by Captain Robertson at Pune. The third of gold mohurs and silver rupees, the private property of Bajirao, entrusted to Naroba. and seized at Raigar in violation of the terms of the said capitulation. And the fourth of gold mohurs, the private property of Baji Rao, entrusted to Naroba and seized by Captain Robertson at Pune. They amounted altogether, including interest which had been calculated upon the property from the time of the seizures, to 36 crores 56 lakhs 7 rupees 70 quarters, but in course of the proceedings of the claim for the property seized at Raigar was given up. The defendants pleaded the general issue and obtained a rule nisi on the ground of His Majesty's interest being concerned, and otherwise for want of jurisdiction, which was on argument discharged with costs, and leave to appeal against the judgment on that occasion was refused to them as contrary to the practice of the court. By the Charter of the Supreme Court at Bombay, the right of appeal is given for any of its judgments or determinations. The right of appeal is given in the same terms by the Charter of the Supreme Court at Madras, and the same terms had been used in the Charter of the Recorder's Court of that settlement. Till lately, the courts in India appear to have held these terms, judgments or determinations, to apply only to final judgments, and that consequently no appeal laid from interlocutory judgments. The correctness of this construction, however, appears to be dubious, since the decision of the Privy Council in the case of the East India Company versus Sayyid Ali Khan. In that case, there were two decrees of the Supreme Court of Madras in a suit in equity. The first dated the 22nd of May 1820, declaring the rights of the parties and directing the accounts to be taken by the master. The second dated the 28th of July 1821, on further directions confirming the master's report. The East India Company on the 26th of January 1822 presented a petition to the Supreme Court for leave to appeal against both these judgments, and that court granted them leave to do so on the 28th of the same month. The case came before the Privy Council on the 2nd of February 1825 on a petition of the respondents to dismiss the appellants, that is East India Company's petition of appeal to the King in Council, so far as it sought to affect or reverse the decree of the 22nd of May 1820. Their lordships granted the prayer of the petition. The grounds of their decision were thus stated by Lord Gifford. Quote, "The charter which gives the liberty of appealing from a decree of the Supreme Court has provided that no appeal should be allowed by that court unless the petition for that purpose should be preferred within 6 months from the day of pronouncing the judgment or determination complained of. Now the first judgment complained of was pronounced in May 1820, and therefore considerably more than 6 months before the application was made to appeal, and it has been fairly admitted in argument. And it could not be denied that was a judgment that might have been brought before us, although it directed a further account to be taken as consequential to the decision of the court as to the right of the parties. If the East India Company chose to prosecute the appeal from the decree upon further directions, there can be no objection, but the question is whether the court below had any right upon that decree upon further directions to give them a right to appeal against the first decree which decided the rights of the parties. This board cannot say they had a right to do so. The complainants might have petitioned especially upon that point, but it must have been in the nature of a special application, stating special circumstances and showing a strong case to the board for permitting them to have that indulgence, and also accounting for their negligence in not having appealed in due time. The application which they have already made is only asking for leave to appeal as a matter of course against the first decree, and this board are of opinion that such permission cannot be given to them, and therefore that the respondent's petition must be granted so as to restrict them to the appeal against the decree upon further directions. End of quote. The East India Company then presented another petition, specially for leave to appeal against the decree of the 22nd of May 1820, stating the practice of the court below as to the refusal of appeals against interlocutory decrees, and accompanied by an affidavit of Sir Thomas Strange, the late Chief Justice of Madras, in which he confirmed the allegations of the petition and stated that during the time he held the office of Chief Justice, if any application had been made for leave to appeal against the order of the 22nd of May, it would have been refused as premature. The petition was heard before their lordships on the 4th of February 1826, and the counsel for the East India Company, Surgeons Bosanquet and Spanky, cited in corroboration of their statement the case Johnson versus the East India Company, First Strange Notes 18. The judgment of their lordships was delivered by Lord Gifford, who, after recapitulating the former proceedings in this case, went on to say, quote, they, that is the East India Company, have now presented a petition praying the indulgence of this board, stating that an error had existed at the Supreme Court at Madras ever since the granting of the charter in the year 1800 down to the present period, and they have procured the affidavit of the respectable judge who formerly filled the highest judicial situation in that court, who swears, quote, that during the whole time he so held and exercised the said office, an established practice existed, founding on a prevailing understanding of the intention and construction of the said letters patent of granting leave to appeal to His Majesty in Council from judgments or determinations of the said Court of Judicature only on the ultimate conclusion of a suit, when the whole suit and everything regarding it, save only execution, had attained maturity, and when the party dissatisfied might have the benefit of such right of appeal to the extent of every part of the proceeding on which error might be assignable. A case has also been stated before us, determined so long ago as 1799, which was before the period of granting the present charter, but the words of the charter then existing were very similar to the present charter, and upon that occasion the court below determined that it was not competent to parties to appeal upon what was considered merely as an interlocutory judgment. Under these circumstances, the question is whether this error, which has prevailed up to the time when this appeal was presented, is such an error as should induce the board to grant the company the indulgence now asked. It has been urged before us that this case ought to be determined as if it was a case pending between two humble individuals. Not only ought it to be so determined, but this court will look with jealousy upon a case where such a powerful body as the East India Company is concerned. We think, however, that as in a case we decided this morning, where an error exists in the officers of a court and the court itself, it will be too much to shut out a party from their right of appeal, and we with great reluctance grant the permission to appeal in the present instance. End of quote. His Lordship then proceeded to state that from the laches of the East India Company in not having previously presented their petition, it would be impossible to grant them this indulgence except upon their paying the whole of the respondents' costs on the proceedings before the council. They then moved the court for leave to withdraw their plea of the general issue and to plead it again with other pleas, showing that the property, the conversion of which was stated in this action, was taken and seized as lawful prize and so by right of war and conquest. This motion was also refused with costs. The court then proceeded to try the action between the parties, and the cause, from the great number of witnesses and exhibits produced on both sides, lasted 22 days. At the conclusion, the court dismissed the action as against the East India Company and gave the judgment and verdict against the appellants, which was appealed against. In assessing the damages, the court declared they gave not only the value of the property at the time of the alleged conversion, but also compound interest at the rate of 6% on it to the time of final judgment. The property in respect of which they intended to give the damages and interest appeared from the terms of the judgments delivered by the Chief Justice, Sir E. West, and the Puisne Judge, Mr. Justice Chambers, to have been Naroba's private property seized in his house, and the 6 bags of Venetians he afterwards gave up. Some difficulty, however, was found on ascertaining upon which of the items of the particulars of claim they were given, as the sum recovered upon the judgment much exceeded what it would have done had the damages been assessed on that calculation. The principal question below was whether the treasure seized was the private property of Naroba or whether it was public property which had been entrusted to his care by the Peshwa and had been conveyed by him to Raigar and brought fraudulently from thence in breach of the capitulation to his house at Pune. This question depended upon a train of very complicated and in many points contradictory circumstantial evidence, and other questions arose as to whether particular parts of this evidence had or not been improperly admitted or rejected by the court below, and whether interest ought to have been allowed in an action of this description. All these questions were argued before the Privy Council, but their lordships gave no decision upon them, and the arguments are not therefore reported. Lord Tenterden. We think the proper character of the transaction was that of hostile seizure made, if not flagrante, yet nondum cessante bello, regard being had both to the time, the place, and the person, and consequently that the municipal court had no jurisdiction to adjudge upon the subject, but that if anything was done amiss, recourse could only be had to the government for redress. We shall therefore recommend it to His Majesty to reverse the judgment. 20th and 21st May 1831. On appeal from Bombay, Lakshman Rao Sadasiv, appellant versus Mullah Rao Baji, respondent. In a suit for the division of the property of an undivided Hindu family, the whole of the property of each individual is presumed sorry, the whole of the property of each individual is presumed to belong to the common stock, and it lies upon the party who wishes to accept any of it from the division to prove that it comes within one of the exceptions recognized by the Hindu law. Lord Chancellor. Their lordships have taken this case into their full consideration, and they are of opinion that no ground has been adduced either in the course of the argument of yesterday or today upon which they ought to reverse or interfere with the decision that has been come into in the court below. They desire it, however, to be distinctly understood on account of the importance of the question, which does not appear, however, to have been expressly raised, that they give no opinion whatsoever in the slightest degree interfering with the acknowledged principles of the Hindu law regarding the relationship which arises from adoption and the consequences that follow from it. We think it right that this observation should be made because there is a passage in a letter from the Chief Commissioner, Mr. Chaplin, dated Pune, April 11th, 1821, which looks as if he, in an untechnical and somewhat popular view of the merits of the decision which he was then discussing, had taken into his consideration the circumstance of one of the parties standing in the relation merely of an adopted son and not of a lineal descendant of the deceased Bhav. For he says, quote, it must also be considered that he is merely an adopted son and not the lineal descendant of the deceased Bhav, and that his own immediate ancestor had contributed in no respect to the acquisition of the property. End of quote. However, the relationship of adoption, the rights belonging to that relationship when established, and the law that gives those rights to the adopted son independently of the fact of his own ancestors having had no share in the acquisition of the property, are by no means touched by the decision that Mr. Mountstuart Elphinstone has come to, which is now appealed from and which alone is affirmed by their lordships. The grounds upon which Mr. Elphinstone appears to have come to this decision were that the proof lies upon the party seeking to accept any property from the principles of partition known to the Hindu law, and that the appellant not having brought forward sufficient proof that this property was within the exceptions recognized by that law, the general rule of partition ought to prevail. It appears from the cases that have been cited in the course of the argument that the exceptions themselves form a sufficient ground for assuming that the proof of them lies upon the party who would seek to bring himself within them. They are very minute in their conditions, and in one instance, that inference appears to be furnished by the rules of the court, restoring property to the operation of the principal after it had been brought within the exceptions. For instance, learning is one of the undeniable exceptions, and if that is proved, it brings the property within the exception, but it is added, if it shall be shown there was equal learning possessed by the other parts of the family, that gives them a claim to it, notwithstanding the circumstance of its having been brought within the exception. So that here one proof brings it within the exception and another, notwithstanding, throws it back again. This is one illustration among many others which might be given. I mentioned another in the course of the argument as to the clothes of the party incapacitated by nature or by accident from procreating children, which appear by the Hindu law to be accepted. Repeat. I mentioned another in the course of the argument as to the clothes of the party incapacitated by nature or by accident from procreating children, which appear by the Hindu law to be accepted. All these details show that the proof must be upon the party seeking to bring it within the accepted case. Now it appears here very doubtful, and indeed, although we may suspect it, there is no proof in the cause that shows how this property was acquired. But it is perfectly clear, as it appears to their lordships, that there was some, although not a large family property, in which the Bhau shared and which was never abandoned by him, whilst he was enjoying his more splendid fortunes in the Darbar at Pune. And it appears too, from the correspondence between him and Bajirao Mankeshwar in the 82nd and 83rd folios of the appendix, that he left his brother in some sort of charge of this property and always appeared to take an interest in it and to receive reports respecting the management of it, though his agent complains of not having received any orders from him. His brother says when he was getting ready to proceed to the appointment which had been provided for him, quote, "You have quite suddenly provided this for me, as for 6 years you have merely employed me in the charge of the fields and etc. at home." End of quote. And there are other letters from Rao Mankeshwar which show that the Bhav was still connected with the property. It cannot therefore be said that there was no property, though it was very small. Nor can it be said that he gave it up, for he maintained a more immediate connection with it than would be supposed natural to a man placed in a much higher situation than the rest of his family and separated from it by local circumstances. Upon the whole, viewing this as a question of Hindu law, upon which it is impossible to speak with any great confidence, and the question appearing to their lordships to have been decided upon proper grounds, throwing the proof upon the right party, and that proof not having been given, it is their opinion that the decree appealed from must be affirmed. With the respect to the costs, we take for granted that the respondents in a large property of this kind will make no application for them, and it would not be an unfit thing. I do not know what the court below might have done to suggest that it would be proper that the costs of the whole proceeding should be paid out of the estate. It is a very large property. The question is whether it is 2 lakh pounds or a larger sum. No objection was made by the council on either side to the suggestion of the Lord Chancellor as to costs, and the order of His Majesty in council was made in conformity to it. Quote, that the decree of the Governor in Council at Bombay of the 20th day of August 1822 be and the same is hereby affirmed, and that the costs of this appeal, both of the appellant and respondent, be paid out of the property in question. End of quote. Ninth and 10th July 1833. Case of the Army of the Deccan. Memorials to the King in Council complaining of and appealing against a scheme for the distribution of part of the booty taken in the war in the Deccan, which had been approved of by the Lords Commissioners of the Treasury, having been referred to a committee of council, they, without hearing the memorialists upon the merits of their cases, advised His Majesty to refer the consideration of them to the Lords Commissioners of the Treasury. Semble that the Privy Council will not exercise jurisdiction as a court of appeal from the decision of the Lord Commissioners of the Treasury as to grants by the Crown of property accruing to it by virtue of its prerogative. In this case, 3 memorials had been presented, one by Lieutenant General Sir Thomas Hislop, late Commander-in-Chief of the Army of the Deccan, another by Major General Sir Lionel Smith, Commander of the 4th Division of the Army of the Deccan, and another by Captain Job on behalf of the force under the command of Colonel Prother, which captured the fort of Raigar. These were met by counter memorials by Colonel Doyle on behalf of the Grand Army and by Messrs. Fletcher, Alexander and Co. as assignees of the Marquis of Hastings, and also by cases which are put in by the law officers of the Crown. All these memorials in cases related to different claims to booty captured in the Pindari and Maratha war, in 1817 and 1818 and depended on long statements involving history of the operations of all of the forces engaged in the war, a long series of correspondence and negotiations which took place during the 16 years that had elapsed since the termination of it, and two hearings before the Board of Treasury, of which it is almost impossible to give any adequate analysis within the limits of a legal report. The following are the principal facts which took place after the close of the war and upon which the greater part of the arguments turned. Between the years 1819 and 1824, various memorials were presented to the Lords of the Treasury by the East India Company, by the Marquis of Hastings, several general officers on behalf of the Grand Army, and Sir T. Hislop. The East India Company prayed for a grant of half the booty taken in the war, the Marquis of Hastings as Commander-in-Chief of all the forces in India, and the officers of the Grand Army claimed to be entitled to share in it. And Sir T. Hislop, on behalf of himself and the army of the Deccan, prayed for an exclusive grant of all of it that had been taken by them. The Lords of the Treasury directed cases to be printed and heard counsel in support of these claims on the 8th of January 1823 and six succeeding days, and they announced their determination upon them by the following minute, dated the 5th of February 1823. My lords, having heard counsel in support of the claims of the Marquis of Hastings and the Grand Army, and of those of Sir T. Hislop and the army of the Deccan, and having maturely and deliberately weighed and considered the documentary evidence laid before them on behalf of the several parties and the arguments of the council, are of opinion that the most just and equitable principle of distribution will be to adhere as nearly as the circumstances of the case will admit to that of actual capture, and that although they are aware that the principle of constructive capture must, under certain circumstances, in a degree be admitted, the disposition should be to limit rather than to extend that principle. Para 1, quote, they are therefore of opinion that the mode of distribution originally intended by the Marquis of Hastings would be most equitable and just with respect to the booty taken at Pune, Mahidpur and Nagpur, and that the booty taken on each of these occasions respectively should belong to the divisions of the Deccan army engaged in the respective operations in which the same was captured, but that as the division of the Bengal army under Brigadier General Hardiman appears to have been put in motion for the purpose of cooperating directly in the reduction of Nagpur, and to have been actually engaged with the corps of the enemy and antecedent to the surrender of that place, this division appears to my lords to be justly entitled to share in the booty captured at Nagpur, and that such other booty arising from the operations against the Marathas in the years 1817 and 1818, as may now be subject to His Majesty's royal disposition, should be granted to such divisions of the Grand Army under the command of the Marquis of Hastings and of the Deccan Army under the command of Sir T. Hislop, as may respectively have captured the same. Para 2. My lords are also of opinion that conformably to the letter of the Marquis of Hastings to Sir T. Hislop of the 12th of January 1818, Sir T. Hislop as Commander-in-Chief of the Deccan Army and all the officers of the General Staff of that army are entitled to participate in the booty which may arise from any capture by any divisions of the army of the Deccan until the said army of the Deccan was broken up on the 31st March 1818. Para 3. My lords have felt it to be inconsistent with their duty to recommend to His Majesty to give his sanction to any agreement for the common division of booty into which the several divisions of either army may have entered, as it is their decided opinion that if the principle of actual capture be not adopted in this case as the rule of distribution, no other correct or equitable rule could have been adopted than that of a general distribution amongst all the forces of the presidencies engaged in the combined operations as the campaign. Quote, Para 4. My lords do not consider that under all the circumstances of this case, it will be expedient to recommend to His Majesty to grant any part of this booty to the East India Company. Para 5. And my lords will submit to His Majesty the recommendation that he will be graciously pleased to direct that his royal grant of the said booty may be made in conformity with these principles, and for the purpose of better carrying into effect His Majesty's gracious intentions in this behalf, my lords will recommend to His Majesty that a grant be made of the said booty to trustees to be appointed by His Majesty for the purpose of ascertaining and collecting the said booty and for preparing a scheme for the distribution thereof, conformably to the principles above stated, which my lords will submit for His Majesty's final approbation and sanction under His Royal Sign Manual Warrant. Para 6. And that if any questions or differences should arise thereon or between the India Company and the said trustees in regard to what may or may not be properly considered as booty, according to the legal acceptation of the term booty, with reference to the principles governing any capture of property from an enemy in Indian warfare and the chartered rights of the East India Company and the true intent and meaning of His Majesty's grant, or if the Governor General or Governor General in Council may have ordered any captured property to be restored, or may have considered any such property as not the proper subject of price or booty, and the said trustees shall claim the same as such, all questions or differences relating to any such property or booty which may arise between the East India Company and the said trustees should be submitted to this board either for His Majesty's decision thereon or for such directions as His Majesty may be pleased to give for referring the same for final adjudication as the case may require. End of quote. In pursuance of this minute, a warrant was accordingly issued under the sign manual on the 22nd of March 1823, by which His Majesty granted to the Duke of Wellington and Mr. Arbuthnot, quote, all and every ordnance, army, artillery, and etc., and other things, being plunder or booty, of every description which had been captured and taken in the wars in 1817 and 1818, and also all monies into which the said plunder or booty or any part thereof might have been converted, as well as all such as might then already have been secured or received into the hands of the East India Company or any of their officers or servants or other persons, as also all such as the said trustees might thereafter recover or receive from the said United Company or any of their officers or servants or any other person or persons whomsoever on account of such booty. Quote, in trust for the purpose of collecting, recovering and receiving all the said booty or the proceeds or value thereof, hereby granted from the United Company, their officers or servants and all and every other person or persons whomsoever into or in whose hands custody, power or possession the same or any part thereof may have come or may now be and remain. End of quote. The warrant then proceeded to direct, in conformity to the Treasury Minute, that all differences or questions between the trustees and the East India Company in regard to the booty should be submitted by the trustees to the Lords Commissioners of the Treasury for the signification of the King's pleasure thereon, or for the final settlement thereof as law and justice might require, and to empower the trustees to sue for the booty and to make allowances for costs. And it then continued in these terms, quote, we do authorize and direct our said trustees to prepare a scheme for the distribution of the booty and of all and every part and parts thereof, conformably to the principles recommended in the said minute of the Commissioners of our Treasury and approved by us, which scheme shall be submitted by them to the said Commissioners of our Treasury for the signification of our royal pleasure thereon. End of quote. And it then proceeded to direct that the trustees should regulate their conduct in the formation of the scheme and in regard to the performance of the duty of collecting, receiving and distributing the booty by the agents entrusted by them for that purpose, and to the notices and notifications thereof, and of accounting for the same according to the provisions of the Act for regulating the payment of army prize money 54 Geo 54 George 3 C 86, and according to the rules and customs theretofore used and observed in our service in like cases. Communications were immediately opened between Sir Thomas Hislop and the trustees, some difference of opinion having however arisen between them as to what did or did not constitute booty, On the 4th of December 1823, Sir Hislop presented a memorial to the Lords of the Treasury, praying that they would afford to the army of the Deccan, as occasion might require, a hearing on all such points as might arise between them and the trustees and the latter and the East India Company as to what did or did not constitute booty. To this, the Secretary of the Treasury on the 14th of the February 1824 replied that their lordships were of opinion that they had no authority to interfere with the discretion vested in the trustees in collecting, recovering, and receiving the booty. Sir Hislop then, on the 12th of March 1824, presented a memorial to the King in Council, praying that he and the General Prize Agent of the Army of the Deccan in England might have communication, so far as the Army of the Deccan was concerned, with the trustees relative to their claims on the East India Company, and that His Majesty would direct that the Army of the Deccan might, as occasion should require, be heard before His Majesty in Council, or such other tribunal as His Majesty should think fit, upon all such points as might arise between them and the trustees, and the latter and the East India Company, as to what should or should not be considered legal booty. On the 25th of May 1824, an order of council was made upon this memorial, quote, that it should be referred to the Lords of the Treasury to consider the same and do therein as to their lordships might seem proper. End of quote. And a letter was written to Sir Hislop by one of the clerks of the council to acquaint him with this order. The Lords of the Treasury, to whom the case was thus referred on the 14th of July 1824, informed Sir Hislop by a letter from their secretary that neither his representation to the Privy Council nor their own renewed and attentive consideration of the case presented to them any sufficient grounds to induce them to deviate from their view of the subject as communicated to him in the letter of the 14th of the preceding February. The trustees proceeded in the meanwhile to collect the booty without much communication between them and Sir Hislop and the agents of the Army of the Deccan, their rule having been, as stated in one of their letters, to receive information but to give none, and when they offered information, Sir Hislop refused to avail himself of it, as the offer was accompanied with a condition that it should not be submitted to any counsel or attorney for the Army of the Deccan unless permission for that purpose had been previously obtained from the trustees. Difficulties, however, presented themselves to the minds of the trustees from the difference of the facts as they appeared to them from those which were assumed at the hearing in 1823 as to the distribution of the booty, and they addressed a letter on this subject to the Lords of the Treasury on the 22nd of June 1825, in consequence of which a minute was passed on the 28th of the same month, reciting the letter and directing that it should be laid before the law officers of the Crown, and that they and the trustees should attend the Lords of the Treasury at an early meeting to be held on the subject. The exact proceedings that took place in consequence of this minute did not appear on the papers before the council. The trustees, however, withdrew their original letter of the 22nd of June 1825 and substituted another, which in fact was a copy of the former one, altered, however, in many respects to the disadvantage of the Army of the Deccan, as the effect of the former letter had been to state the opinion of the trustees that the booty should be divided amongst all the divisions of the Army of the Deccan, including the division under Colonel Prother. In the latter or substituted letter, they stated, without making any express declaration of their sentiments as to the distribution, that the booty had been captured not in consequence of the operations of any particular division or body, but of those of the whole army, which latter expression was, in all the subsequent discussions, held to mean both the Grand Army and the Army of the Deccan. On the 10th of September 1825, a memorandum was sent to the First Lord of the Treasury by one of the trustees, the Duke of Wellington, in which he reviewed generally the operations of the troops of both the Grand Army and the Army of the Deccan during the campaign, and the conclusion he drew was, quote, that there was previous concert and association between the two armies and between several of the divisions of each of them actual military cooperation. End of quote. Sir Hislop, who was not aware of any letter having been addressed by the trustees to the Treasury, made on the 17th of September 1825 an application to that board by letter requesting to be informed of the scheme of distribution which might have been recommended by the trustees before it was submitted for His Majesty's approbation. To this application, he received a reply from their secretary in consequence of minute passed on the 28th of September 1825, informing him that, quote, the trustees had reported as their opinion that with the exception of certain sums amounting together to about 1,50,000 pounds, the produce of sales of captures made in the daily operations of the troops of the army of the Deccan, no booty was captured at Nagpur, that none had been realized that was captured at Mahidpur, and that the whole of the booty, with the above exception then at the disposal of the crown, fell into the hands of the officers of the East India Company after the army of the Deccan was broken up, that these facts being different from those which appeared to have been assumed in the arguments addressed to their lordships in January 1823, they deemed it to be indispensably necessary before they could proceed to submit to His Majesty a scheme of distribution for the purpose of carrying their said minute into effect, to afford an opportunity for any further explanation or remark with reference to these circumstances that the parties might be desirous of offering. End of quote. In consequence of this communication, a meeting took place between the Lords of the Treasury and the Council for Sir T. Hislop and the army of the Deccan, and for the Marquis of Hastings and the Grand Army on the 6th of December 1825, in order to settle the points to be discussed. The Council were then informed that the Lords adhered completely to their previous minute, but that they had understood from the trustees' report that the minute was founded on facts not warranted by the actual state of the case, and the point they wished to have argued appears to have been whether all the booty, except about 1,50,000 pounds, was gained by actual capture, or whether it was a capture made as a general result, but not booty actually taken on the spot at the time the places were taken. Subsequently to this meeting, a copy of the substituted letter of the trustees was given to the council, and on the 9th of January 1826 and the 3 following days, arguments took place before the Lords of the Treasury. At the commencement of these, it was stated by the First Lord, Lord Liverpool, that the board had received a memorial from the Marquis of Hastings, which was not, however, produced, praying them to advise His Majesty to refer the measures in question to the consideration of the Privy Council, and he expressed a wish to know whether the parties were desirous that such a recommendation should be made. But the Council for the Grand Army, who also appeared for the Marquis of Hastings, objected on the part of the Grand Army to this proposal being acceded to. The determination of the Treasury after these arguments was expressed in a minute dated the 16th of January 1826 in these terms. Quote, my lords, assisted by the trustees of the Deccan Booty, Lord Bexley, and the law officers of the Crown, having heard counsel on behalf of the Marquis of Hastings and the Grand Army, and also on behalf of Sir T. Hislop and the army of the Deccan, upon the subjects of dissension relating to the distribution of the Deccan booty, which have arisen out of the difference between the actual circumstances attending the capture of a large proportion of that booty, as stated by the trustees, and those which were assumed at the hearing before their lordships in January 1823, and having maturely considered the arguments severally stated by the council, and also the whole of the documents upon the subject of this booty now before the board, are of opinion, first, that with respect to all that portion of the booty now at the disposal of the crown, which is described as having been taken in the daily operations of the troops, the distribution thereof should be made to the actual captors according to the terms and conditions of the minute of this board of the 5th of February 1823 and of the warrant of His Majesty of the 22nd of March following. Second, that with respect to that part of the booty which consists of the produce of arrears of tribute, rent or money due to the Peshwa, it appears to my lords to have been acquired by the general result of the war and not by the operations of any particular army or division, and they are of opinion that it ought therefore to be distributed in conformity with the alternative stated in their minute of the 5th of February 1823 as being the only correct or equitable rule if the principle of actual capture cannot be adopted, which amongst the forces of all the presidencies engaged in the combined operations of the campaign. Third, with respect to the property captured at Nasak, probably Nasik, My lords are of opinion that the booty recovered at that place cannot be distributed upon the principle of actual capture and ought therefore to be divided amongst all the forces of the presidencies engaged in the combined operations of the campaign. Fourth, with respect to the booty recovered at Pune, alleged to have been removed thither from Raigar, my lords are of opinion that this booty cannot be distributed upon the principle of actual capture to the force by which Raigar was taken under the orders of the government of Bombay, unless it can be proved by the captors of Raigar that the property in question was actually in that fort at the time when it was taken. In default of which proof, my lords are of opinion that this booty ought also to be distributed among the forces of all the presidencies engaged in the combined operations of the campaign. Fifth, with respect to that portion of the booty which is stated to consist of money recovered on account of deposits made by the Peshwa, my lords are of opinion that any part of this property which can be proved to have been in Pune at the time when that place was captured, viz. On the 17th of November 1817, ought to be distributed to the captors of Pune according to the terms of the minute of the 5th of February 1823 upon the principle of actual capture, but that with respect to those parts of the above property as to which such proof cannot be established, such monies or effects must be considered as having been acquired by the general results of the war, and as such ought to be distributed amongst the forces of all the presidencies engaged in the combined operations of the campaign. Sixth, with respect to the share on the commander in chief in the distribution under the several heads above enumerated, my lords are of opinion that the Marquis of Hastings ought to share as Commander in Chief in all those cases in which Sir T. Hislop is not entitled to share as such under the terms of the minute of the 5th of February 1823, wherein it is declared that Sir T. Hislop, as Commander in Chief of the Deccan Army, and all the officers of the General Staff of that army are entitled to participate in the booty which may arise from any capture by any of the divisions of the army of the Deccan until the said army of the Deccan was broken up on the 31st of March 1818. My lords are further of opinion that the general rules of division hitherto adopted in distributing booty to the forces in India among the several classes and ranks of the army should be adhered to on the present occasion. End of quote. Sir Thomas Hislop presented two memorials on the 8th of April and 20th of June 1826 to the Lords of the Treasury, praying them to reconsider their minute of the 26th of January, to which on the 30th of June they replied by their secretary that they saw no grounds for doubting the correctness of the decision they had come to. The trustees, in the meantime, prepared a scheme for the distribution of part of the of the booty. It was approved of by the Treasury, and a warrant was issued by His Majesty on the 30th of September 1826, approving of the scheme submitted to him for the distribution of certain parts of the booty taken in the daily operations of the troops under the command of Lieutenant General Sir Thomas Hislop at Pune, Mahidpur, Nagpur, Singhur, Purandar, south of the Krishna, Vasuta, Solapur, and the hill forts in Khandesh, and directing the distribution in accordance with it of 21,058,168 rupees, 3 annas and 3 pice, being 153,608 pounds 4 shillings 8 pence. The trustees accordingly inserted a notice in the Gazette of the 21st of November, following that this sum would be distributed, which was headed Grant to the army which served under Sir T. Hislop, GCB, the war against the Pindaris and certain of the Maratha states in the years 1817 and 1818, and the money was distributed under it, Sir T. Hislop receiving his share as Commander-in-Chief. The trustees then proceeded to prepare a scheme for the distribution of other parts of the booty. It was approved of by the Lords of the Treasury. Before, however, a warrant was issued in accordance with it, Sir T. Hislop was permitted to see it, and he presented 4 memorials to the Lords of the Treasury, praying that the warrant might not issue and that he might be heard before them by counsel against it. With all these requests, the Lord of the Treasury refused to comply, and a warrant was issued by His Majesty on the 13th of February 1828, reciting that he approved of the scheme submitted to him for distribution of part of the booty acquired by the general result of the war by the forces under the command of the late Marquis of Hastings, amounting in all to 41,039,803 rupees 14 annas 1 pice, and directing the distribution of it accordingly. The trustees accordingly published a notice for distribution in the Gazette of the 29th of February 1828, headed, quote, Grant to the combined army which served under the command of the late most noble Francis Marquis of Hastings, KG, Commander-in-Chief of all the forces in India, engaged in war against the Pindaris and certain of the Maratha states in the years 1817 and 1818, end of quote. In this scheme and warrant, Sir T. Hislop was not treated as Commander-in-Chief, but as a Lieutenant General and second in command to the Marquis of Hastings, in which latter character 5,500 additional shares were granted to him. On the 1st of March 1828, Sir T. Hislop addressed a memorial to the King, praying to be heard before His Majesty in council against this scheme, and that the distribution under the warrant might be stayed. In answer to this memorial, he received a letter from Sir R. Peel, the Secretary of State for the Home Department, informing him that His Majesty had been advised not to revoke his warrant or to allow of an appeal to the Privy Council. The booty was accordingly distributed under the warrant, Sir Thomas Hislop receiving his share of 1,984 pounds 12 shillings 10 and 3/4 pence, and his agent giving a receipt for it as his share as second in command to the Marquis of Hastings. The share of the Marquis of Hastings as Commander-in-Chief, which amounted to 44,201 pounds 0 shillings and 7 pence, was paid into the Court of Chancery by the trustees in a suit instituted against them by the executors of a Mr. Sims, and afterwards continued there in another suit instituted against them by Mrs. Alexander and Co., to whom the Marquis had assigned it. Sir T. Hislop was made a party to the suit and claimed this share as Commander-in-Chief. His claim was, however, rejected by the Master of the Rolls and afterwards on appeal by the Lord Chancellor on the ground that the Crown